And now I would like to introduce today's speakers. Ed Broker is a partner in our business law practice group and a member of our corporate venturing team. He balances business results and mitigation of legal risks, concentrating his practice on commercial agreements, corporate and board governance, software licenses, finance and equipment leases, and helping clients in transitional situations, including asset monetization, business expansion, and capitalization. He represents a broad array of national and international clients with concentration in the fields of advanced manufacturing, IT and life sciences, sales and distribution, and hospitality and gaming. We also are happy to welcome 3 outside speakers today. Craig Carpenter is Vice President and Associate General Counsel of Ingram Micro, a privately owned global leader in technology and supply chain services. Ingram Micro has operations in 52 countries and sales in 160 countries in 6 continents. Ingram Micro is part of the H&A Group, a global Fortune 500 diversified holding company. Joseph Perkins is Corporate Counsel for Allison Transmissions, the leading manufacturer of automatic transmissions for heavy-duty vehicles in the world. Prior to joining Allison, Joe was General Counsel for Nibco Inc., and before that, served as Deputy General Counsel for the Americas and Legal Quality Champion for Cummins Inc. Joe has over 20 years of experience representing global manufacturing companies. Finally, Lloyd Porter is Director, Global Trade Compliance for Cook Medical, the largest privately held medical device manufacturer in the world. Lloyd has over 20 years of experience working in trade compliance for multinational manufacturers in the defense and medical device industries. Thank you for being here with us today. And with that, I will turn it over to our speakers.
Thank you, Kathleen. My name is Ed Broker, and I'm very happy to be joined with this wonderful panel this morning or this afternoon to talk about export controls and trade sanctions. It's been an interesting 2017, and 2018 promises to be even just as interesting. So everybody should have in their slide decks an agenda. We're going to briefly go through some of the materials, and then we're going to hand it over to some questions and answers with the panel, because I think that that's the most valuable portion of this afternoon, to hear the insights and expertise from our 3 great panelists and hear what they have to say. So with that, let's begin. The Export Administration Regulations, the EARs, are governed by the U.S. Department of Commerce, and what they do is they regulate commercial dual-use sensitive items. And so not every export of every product obviously is subject to some sort of trade control, but the United States tries to protect against the export of sensitive items, both in the commercial space and then also in the military space. So when you have a sensitive commercial item, those are governed by the Department of Commerce, the Export Administration Regulations. And then when you have dual-use items, those are governed by both the, by the EAR, not by ITAR. So as you can see on the slide, the EAR is administered by the Department of Commerce Bureau of Industry and Security, the BIS. And just a little bit of lingo here, so if you are faced with the situation and you can talk the language, the proper terms are that the items are subject to the EAR. And so if they're subject to the EAR, then you'll know you'll need to get a license of some sort in order to export. So, what sort of items are subject to the EAR? Those are generally going to be commodities, software and technologies, dual-use items. And when we talk about dual-use items, those are commercial items that also have a military use application associated with them. So if you have I know for Cummins or Allison, we have an awful lot of engines or transmissions that 90% of them are in commercial vehicles. So those are not subject to any sort of regulation, but if they are put into a military application, then you're going to run into some problems. And so those sorts of transmissions or engines are referred to as dual-use items. And so then certain trade activities with sensitive end users or end uses like military, obviously, are also subject to the EAR. Items not subject to the EAR are military items because those are regulated under ITAR. Nuclear-related items, those are subject under the Nuclear Regulatory Commission, and then certain non-U.S. and public domain items, those are outside the EAR as well. So what does the EAR regulate? The EAR regulates and governs the export of an item. And so, when most people think of what is an export, it's the easy one. It's the physical shipment out of the U.S. So you load your engine or your transmission onto a big old crate, and it gets put onto a boat and it gets shipped overseas. That's an export. That's the easy one. Then exports, because lawyers are tricky and creative, they created cross-border electronic transmissions of software and technology. So if we have a server in the United States that gets accessed overseas, those are also exports. And then we have what are called deemed exports. And what that means is that you have a sensitive technology on your laptop and you're sitting in the United States, but you have a foreign national access your computer screen, or even just sitting in a meeting talking to them, that is sometimes deemed an export of that technology. So those are issues to be careful about. And here are some more additional things. They're very broad. It doesn't necessarily require sales, so intercompany transfers. So I know that Cook Medical has facilities all over the world, and so when you ship a product from Bloomington over to your facility in Denmark, that is an export. Also, one of the big ones that people don't necessarily understand, when you have your cell phone and you pass through customs and you get on the airplane and then you arrive in the country, that's an export of that technology or whatever is on your laptop or your cell phone. So those are one of the big things to be careful of. It includes both temporary and permanent exports. So just like that cell phone, when you travel overseas, that is a temporary export of that technology. It also includes re-exports. So that means that items that were made outside in the UK, for example, but have US origin content, and then those that may be subject to the EAR, and then that transfer from the UK goes over to Denmark, that's called a re-export, and then transfers. So if I have a business transaction involving my facilities both in the United States and overseas, and I sell it at a parent level, then that's a transfer of technology potentially. I'm going to skip through some of the license and the details of the licenses because, again, we're trying to make time to hear from our panel. But essentially, what happens is that if you are going to export a technology, you're going to have to review what the purpose of that technology is and the location of where that technology is going to be used. And then the EAR has a complicated spreadsheet, and you go through the spreadsheet and you figure out, is this what is going to be the potential use? What's the classification? And then you can determine what sort of license and what license is required, if any. Let's see. So then we'll get to what items are not subject to the EAR. Again, as I mentioned, the EAR is kind of limited. It's only for sensitive technologies, so not everything is subject to the EAR. Publicly available technologies and softwares are not subject to the EAR if they've already been published. Other sorts of technologies that relate to fundamental research, even though they may be sensitive, may or may not be subject to the EAR if they're educational or they're included in certain patent applications. Those are generally not subject to the EAR. So then people have heard about ITAR, the International Traffic of Arms Regulations, and ITAR is very similar to the EAR, but it's limited only to defense materials. So ITAR is regulated by the United States Department of State, and the governing jurisdiction within the Department of State is the DDTC, the Directorate of Defense Trade Controls. And again, just similar to the EAR, the ITAR governs the exports, re-exports, and transfers of defense articles, including technical data, and defense services. And again, the defense services is one of those interesting items that sometimes trip people up when they have to deal with ITAR. It also covers brokering of defense articles and services. So even though you may not be a manufacturer or an exporter, if you're a broker and you're acting as the middleman between the manufacturer and the foreign government that's acquiring your military product, then you're going to be subject to ITAR. And then similar, it covers manufacturing facilities in the United States of defense-related articles. So what are the items that are governed by ITAR? Those items are generally covered by the United States Munitions List. Now, the Munitions List governs 21 categories of items. Interestingly, though, they're going through a process right now of removing some of the items. So I think, if I remember correctly, perhaps I think bullets were just recently removed from the Munitions List. So some of the things that are obvious or may appear to be obviously military items or munitions items may not necessarily be. So keep an eye on the export control reforms and what is actually on the current version of the Munitions List. The Munitions List or things governed by ITAR focus on the item, not the use. So even though it is going to be put into your commercial transmission is going to be used in a Humvee, that doesn't necessarily make it subject to ITAR, but it is going to be subject to EAR. So you focus on the item, not necessarily the use. And then as with EAR, the definition of export is very, very, very broad and includes both physical transfers, deemed exports, performing a service for and on behalf of the United States, or for and on behalf of a foreign person, whether it's in the United States or abroad. I know that there was a big investigation a couple of years ago into Blackwater, where they had the training facility in North Carolina for the Saudi family, and I don't think that they had an ITAR license, even though they probably should have at the time. So it also includes registrations and controls of ITAR-controlled items to a foreign person. So what is required through the ITAR registration? Obviously, manufacturers of defense articles, even if they are just purely selling those defense items domestically, are required to get registered with the DDTC, and that registration is a disclosure requirement. It's a form that you have to fill out and provide a bunch of background information. And then obviously exporters and then brokers have to be registered with the DDTC. The registration requires annual compliance updates so that you have to maintain your registration current. It also requires updates upon certain events. So whenever you have a change of an officer or a board of directors or a material shareholder, you have to provide 5 days notice of any of those transactions. In addition, and we'll touch on this in the M&A context, there's a 60-day advance notice of transactions involving sales to foreign acquirers. So if you're an ITAR registered facility, even if you're 3 levels down in the food chain, if there is a transaction involving a foreign purchaser anywhere within that food chain, that's going to require a 60-day notice clearance. And it's just a notification. There is no approval process, unlike some of the others. So unlike HSR filings or CFIUS filings, the DDTC filing is merely a notification. And then ITAR also requires the maintenance of a compliance manual. So the development and maintenance of a compliance manual and training program is required under ITAR. So ITAR license are generally required for any exports, re-exports, or transfers of defense articles or defense services, and there are only a very limited number of exemptions that are available, mostly dealing with our very close allies like Canada and the UK. So then we get into OFAC and sanctions. And in the United States, OFAC of the Department of Treasury, the Office of Foreign Asset Control, is the governing body that is associated with making sure that transactions are done appropriately and commerce is not done with any sort of prohibited entity. And there are three different types of sanction regimes. There's an entire comprehensive sanction regime, and those are only limited to 5 different regions, and we'll talk about those in a second. Then there's targeted industries, and then targeted individuals are how the sanction regimes are set up. So for OFAC, there's comprehensive sanctions, which means essentially that all sorts of transactions are prohibited, with obviously a limited exceptions because lawyers write the rules. But so where are the 5 comprehensive sanctions? Obviously, everybody's heard about Iran. Then there's Syria, and then the Crimea region, which is associated with the Ukraine dispute with Russia. Then North Korea, and Cuba as well. Those are the 5 territories that have, or 5 regions that have comprehensive sanction requirements. Sudan was just recently removed in October from that list. So while they're still subject to some particular sanctions, Sudan is not under one of the comprehensive sanctions. So then we go into limited sanctions, and limited sanctions, as it describes, is some dealings are prohibited, but others are very restricted. So where are those limited sanctions? Obviously, we have a dispute right now with Russia, and Venezuela this year in 2017 has become a hotbed of issues associated with sanctions and the Maduro regime. So then they have a list-based set of sanctions. So 13 countries have specific items. A lot of this is associated with oil and gas or other sorts of blood diamonds and other sorts of bad actor type things. So those are on list-based sanctions. Then they have targeted groups of individuals like narco-terrorists, criminal organizations, counterterrorism, non-proliferation sort of things. So you can see the list of how it gets done. But most people understand when you talk about the OFAC-List are especially designated nationals, and those are people that are specifically blocked. A lot of those are criminals and dictators and bad guys, or people that the United States wants to specifically target as having done something in violation of human rights or otherwise. And those are targeted to individuals, but every time you do a transaction, you have to do your due diligence in order to know whether or not one of these SDNs are involved either directly or indirectly in your transaction as a counterparty. So obviously KYC, know your customer, there's a significant amount of obligations associated with that. So this is an important screen here, and there's an awful lot of information associated with it, but it's kind of the summary of what OFAC is. So comprehensive sanctions just essentially means that there are no import-exports from the targeted country, no new investments, and it's very limited. Other sanctions are very specific and targeted, and I put a link on there to the OFAC's website because it's a very user-friendly website. Some of the pages get kind of dense, and the updates are not readily available, but it does show you all the various sanctions if you go to that, and all the updates that are the current regime for the sanctions. And then, importantly, OFAC applies to U.S. persons, and U.S. persons are very broadly defined. So obviously, obviously as citizens and permanent residents in the United States. It also applies to U.S. companies and U.S. branches or foreign branches of domestic companies. And then it also applies to any person or company located within the United States. So if you're a domestic branch of a foreign company, OFAC regulations would apply too. And it applies to dollar-based transactions. So Iran's been in the news very recently. Obviously, 60 days ago, President Trump refused to certify that they've been complying with the nuclear arms treaty. Under the way the structure was set up, today or yesterday, Congress was supposed to rule on whether or not they're going to override President Trump and actually certify. I've been searching the papers, but I haven't seen anything today, so I don't know what happened. But essentially, even though Iran came off of the nuclear sanctions, trade with Iran under the various other sanctions regimes, so terrorism or those sorts of things, have been restricted. So even though some of your competitors in Europe may be able to sell into Iran, anybody dealing in the United States is not able to. Interesting also, you'll see item number C, the state level sanctions. This is something where people get tripped up a lot as well, and that is that many states, Indiana or California obviously is one of the big states, have their own sanctions list involving some particular issues, and so trade with Iran for California companies are prohibited as well. So that's, not only do you have to deal with OFAC and the Department of Treasury, you sometimes also have to deal with states in their sorts of things. There are licenses that are available. Don't know, given that Congress hasn't acted yet, what's going to happen. So don't know whether those licenses are going to remain in effect. We'll talk a little bit later with Lloyd about the humanitarian exemptions, and also some completely foreign transactions are prohibited. So the penalties, obviously, $1 million fine, 20 years in jail, those get everybody's attention. There's also civil penalties, and it's a strict liability regime. So if you are violating sanctions, it is a strict liability. So you're going to be ultimately caught, and you're going to have to pay a fine or go to jail. You can also be designated as an SDN or included within the denied parties list. You can be debarred from contracts. Importantly, you can be subject to false claims or QTAM suits. And there's also an awful lot of whistleblowers out there. So, you're going to ultimately be caught, so you better comply with the rules and the regulations. You also are subject to reputational risk, and there's a 5-year statute of limitations. So it's a big deal. Here are some recent big fines. These are the top 6 fines. You've got Standard Chartered Bank, almost $1 billion. You got ZTE, which happened this year, which is $1.2 billion. You got Commerce Bank in Germany, $1.45 billion. You got HSBC Bank, $2.5 billion. And then the big one, BNP Paribas, almost $9 billion back in 2014 for OFAC-related things. We'll get to the question about the aircraft from Boeing to Iran in a little bit. So M&A issues, the issues associated with M&A and trade controls are very important. You might need to be subject to a license in order to receive some of the due diligence associated with if you're one of your targets. And you also might have some deemed export issues. So if you're a target sitting here in the United States and you have sensitive information, if the acquirer might have a foreign national as part of their due diligence team, even though it's a domestic team, they may be subject to having some sort of license. You also have the timing and the pre-clearance issues. One of the big issues associated with foreign acquisitions is CFIUS, the Committee on Foreign Investments in the United States. They have the ability to actually unwind transactions. So unless you get approval, and it's a voluntary filing, so you're not obligated to file, you're strongly encouraged sometimes. But the big hammer is even if you should have filed and you didn't, and you close the transaction, CFIUS has the ability to unwind the transaction. And Craig Carpenter just recently was involved as part of a transaction. So I'm going to turn it over to Craig and let him talk a little bit.
Yeah, okay, thank you, Ed. There's a lot of good information out there. Even on their website, it's actually pretty informative. It's regulation driven, but for those that don't know, it's a combination of a three-letter agency. It's intrigues me. I'm never like in a distance, but it's they're charged with looking at transactions from a national security perspective, and trigger is a fire. And I won't go through the whole list. You can find a lot of this information on the internet, but it's the typical players. You have Treasury, Justice, Homeland Security, Commerce, Defense, State, Energy. It's a committee, and they review these transactions in a unique way. They have kind of a mix of on transaction. It's not a huge organization. I just the last couple of years, pretty large uptick in Chinese U.S. companies. Ingram Micro is work for it's fish. It's mid-40 in revenue. You never thought that there'd be a bigger fish out there coming and gobble you, but all of a sudden there was a company, H&A, which is a Chinese conglomerate, that's a lot larger, and it found that it's acquisition, and so it closed about a year ago. But we tell you from
Excuse me, Ed. This is Fred Ganson, Madison. If you could move the mic a little toward our speaker, I think in our other offices we might be able to hear a little better. Thank you.
Okay, I can talk maybe. And we entered into a deal, and these things don't close out. A lot of other filings you need to make, especially since we're located in so many different countries. We had to file in a lot of places. But I'll just give you some practical takeaways from what it was like. Because not everybody's gone through this, and you may never have to. But as I said, there's always a bigger fish. So be prepared. The first thing, the first consideration is, when you have a foreign buyer, is to think about CFIUS before you actually, right at the beginning of the talks. And you may want to, do some diligence early on with the buyer to see if you're going to fall within that whole regime. Appoint a lead, really, I think is a good tip, someone that's going to be the point person. And, for inside counsel, I would suggest that you find someone that has experience in this area. And if you're deal counsel, external deal counsel, you may want to find someone that's an expert in this, because a lot of it is, there's not a lot of volume in this area. There's not a lot of experts, honestly. But I would strongly encourage that, and most of those folks are sitting in D.C. As Ed pointed out, there's there are a number of transactions that have been withdrawn because of running into CFIUS in recent years, and there have been a number of deals that have been stopped. You don't have to, as Ed said, it's voluntary, but you may be invited to come back later and do it if they find out about it. Because they do. They look at they look at the news articles and public disclosures and the Wall Street Journal and all these things, and you get congressmen seeing that the Chinese are gobbling up all of our good companies, and it gets and you get a call if you decide not to voluntarily file. It can be a lengthy process too, because it's iterative in nature. They'll ask you a set of questions, base, and sometimes they'll arrange for a meeting or interview so that you can have basically put together a pre-filing to run by them first. But the process can be iterative, and you may get a set of questions. It's like apples, oranges, and it's another stage. So it's not real logical, honestly. It doesn't have to be, and sometimes it's intentionally not.
It's political.
Yeah.
So if they hear a juicy tidbit, then they'll focus on that, even though that may not be the true source of the transaction.
Yeah, and so when you're going into one of these, you have to look at it from the buyer's side and the seller's side. On the buyer's side, well, is it foreign government owned, or is it from a company that's based in an area that may be deemed to be hostile, China or Russian, are examples. And then looking at the target, the U.S. business, is it a government contractor? That's a pretty obvious one, or is it in a sensitive sector, or critical infrastructure like energy, agriculture is the big one, or telecom as an example, transportation. Does it deal in advanced technology? And that's one of the reasons why we're the largest distributor of technology in the world. We have our own, we do develop software and have our own cloud-based products and move a lot of technology. We do some configuration and those sort of things. So those are things that we thought would probably be interesting to CFIUS. And the other one is, do you have access to sensitive information? So you're talking about banks, insurers, healthcare providers, R&D companies, but all sorts of information. It could be not just personally identifiable information. It could be greater data about consumer sales within the United States. Our country might be interested in learning a lot more about that and habits of buying in our company because of the number of transactions we conduct. Like just to put it in perspective, we move 1 of every 3 mobile devices in the United States that we touch on. So that's a lot of information, right? And we're shipping over 500 million units a year. We have a business that is ITAR, which is IT Asset Disposition. So we go into your banks, your law firms, and other places. We take their servers out, we wipe them, and we remarket them. So there's a lot of information that comes to our company. So that's an interest to early on, I think you need to consider, are you going to consider a mitigation plan too? Because the one thing you can do is if you have we do government contracting. We could have considered if that was the problem, we could divest. You can wall off certain ways, and you're gonna have to take a look at. There are other things you can do too that help. This is out there. You can limit through your governance, board members, and you can invite, national security experts to help to your board to help administer your program. You may end up entering into an agreement to limit the number of foreign board members that may be part of it. You may end up agreeing to limit site access and limit the sharing of IP or any integration of systems. One of the keys is know that up front, because if you're representing a buyer, use that early on and build it into your docs. So you're going to have termination provisions and a breakup fee. I don't know. I haven't seen a product out there yet, but there may be insurance you can the parties can buy. But these things are uncertain, so you need to think about it. Are you allowed to be a condition proceed to closing your transaction, or are you going to close over it? You can understand too that you can this can come up after close, right? You said it. So even if you don't file, it can happen afterwards, and they can undo your deal. So what happens if that happens, right? And deal with it in your acquisition documents. I won't get into the notices. There's some good materials out there on that and how what goes into those and the timelines. I think it's more important to just a couple of interesting takeaways. I think early on too, it's important to have a good public relations and maybe a lobbying plan to get in front of this, to talk to members of people on the Hill, so they don't run out and use it politically to charge the situation. Have a plan too, and a public relations to deal with your employees. They're going to want to know what is it about, what is CFIUS? Why are we going to do this? What is it going to be like to be owned by a Chinese company? Oh, does this mean I don't have to, when we close this, the FCPA doesn't apply? You get all those kind of, the answer to that is, no. But you have to have a plan for that. Nice try. Yeah, good thoughts. Have a real developed plan, and that takes some thinking, and have a plan to combat your competitors, because your competitors are going to say, well, look, these guys are going to be 4-0, they're going to go through CFIUS, and you'll have the same thing. Vendors that may have a concern, customers, but I think that you can, playing it smartly, you can use that to your advantage and say, well, my competitors haven't gone through a CFIUS review. I have, so they actually should be a little bit more safe, shouldn't they? In the grand scheme of things. A couple more points. I would say that you're going to have to plan on, if you go through it, you enter into an agreement with the government. You may have ongoing monitoring. The groups and the other folks in the world may end up showing up at your site regularly. Make sure you're complying. You may have to appoint a chief security officer that acts as the interface with CFIUS, or your designated kind of case agent kind of thing. And there will be ongoing monitoring. You may have to actually train your associates on all these things too, because you can't let them trip you up. And in the interest of trying to please the new owner, they do something that they didn't realize there was a violation of your agreement not to do, which would be integration with systems or sharing of information that's sensitive. And those are just some keys to take away. Be prepared to educate, and then educate, and it's got to come from the top down. So you have to be prepared to have your C-suite or execs well versed in it, so that they understand what they have to do. They'll be the first ones talking to the vendors and the customers, and combating the competitors. So I think those are some keys to take away. Get into it early, get an expert, and even if don't dabble in this. I think it's part of it. You have to have some relationships with that committee out there, and it's a small committee, and they can't process things very, very quickly. I mean, they're limited in the amount of resources they have.
Well, and the whole purpose is national security. So in and of itself, it's going to require security and sensitive information that you need to make sure is continually protected. So
and I think
people don't.
Right. And I think to be ready going into it, you need to have good systems to be able to immediately gain access to information in all the four corners of your company. It could be things like site, locations. Do you have a good real estate tracking system? Because they're interested in knowing, your sites in proximity to, sensitive other sites. That's one thing that they're interested in, as an example. And do you know what technology you develop? And can you list all the products that you handle? So be ready and have systems that you can tap into quickly as the questions come in.
Thanks, Craig. That was very informative. For M&A, you need to also protect against reps and warranties. Good, appropriate reps and warranties dealing with disclosures and ITAR related and EAR related stuff. There's successor liabilities, both on an equity and an asset purchase. So there are cases, and when you do an ITAR notice requirement, one of the provisions in the notice letter says that the acquirer is going to assume the liabilities of the acquired. So even though it might be an asset deal, you are still assuming under your contract with when you file the notification. So now red flags, and again we're running through here. So you know, the best practice is know who you're dealing with, know your customer. BIS, the Department of Commerce, has created kind of a red flag list of items. I put the internet site or the link on there. You need to train your employees on the risk of diversion, and diversion means that you sell a product in a legitimate transaction, and unfortunately your counterparty is not necessarily the most ethical, and he sells it to Iran or diverts it someplace where it's not supposed to be. So you need to train your employees about the risk and who they are. You also, some of the big red flags are unusual transactions. Joe, why don't you tell us some of your red flags that you come across?
Well, you've certainly hit on some of the big ones, like you know, things like if you're working with an agent, for example, and or an intermediary, and they're not very clear about who the end customer is, or maybe what the end use of the product is going to be. You know, those are things that are certainly big red flags that should jump out at you, and other things like that. I mean, it's whenever something feels a little shady or makes you uncomfortable, then you know that immediately, especially as lawyers, we need to start asking questions, really drill down, and kind of get to the bottom of it.
I got a big gut, so I trust my gut a lot. So we'll see. Lloyd, you'll notice that some of the big liabilities were associated with banks. And they have an awful lot of your customer obligations.
Absolutely.
So how is it that you, as part of Cook Medical, train your employees or figure out who your customers are?
Yeah, there's. I think we try to take a multifaceted approach to awareness and training. I mean, it's sometimes you have failures in your system and in your processes because you've put together, let's say, an e-learning course that your customer service people, salespeople are going to take, and that's all that happens. They kind of go through it each year, they check it off, and then it kind of goes out of their mind. I think one of the important things in this area to build awareness around red flags is, it's got to be continuous education, multi-points throughout your business cycle or your annual period, and you have to approach people, I think, with different modes of training. Okay, the e-learning is great, and we make a lot of use of that in our organization. But then there's having coffee and donuts with the customer service team, just getting over there, becoming a face, and talking through some possible real life scenarios. Kind of doing a little test practice case. What would you do if you had a telephone call like this or whatever? I think those kind of in-person and face-to-face trainings can be really valuable and really useful. And then I guess the other component is making sure that they have tools in their hand, desk reference charts, guides, things to be aware of that you tailor them to that business. Because in the area of red flags, every business is different. So what's a red flag for Joe at Allison Transmission isn't going to look anything like a red flag for Lloyd at Cook Medical when they're dealing with a distributor that suddenly has a curious request. Instead of delivering to the normal warehouse location, we're being asked to send it to a different country without explanation. There could be a legitimate reason for something like that happening, but in my training and interactions with people, I try to say, anytime something fits out of the normal routine, we have to stop, talk about it, and look at it. And BIS says, you're not required, absent red flags, to go behind your customers' representations, which they, so you don't have to secretly check them out necessarily if everything seems to be in good order. However, when you do see a red flag, you are obligated to stop and seek a resolution there. Or otherwise, if you don't, and then later on it's discovered that something has gone wrong, that will be imputed to you as knowledge that you knew or should have known something was wrong about that transaction. So it's important try to, approach people in different modalities and on an ongoing basis rather than the typical, well, let's just, have a once a year annual training and call it good.
Oh, come on, take the box really
Yeah.
quick, doesn't it? So I put this chart up here because I really like it, and B, I think it's kind of cool, that shows really bringing it all together, that we've only talked about the United States, but other jurisdictions, this works with the EU, but other jurisdictions, APAC, every country has their own trade regulation and controls. But what this chart shows is some of the jurisdictions. The dark red is a combination of both the EU and the United States. So there's some level of sanctions associated with every one of those deep red countries. The blue are United States only restrictions. So you'll see Cuba and Haiti on there. For the rest of the world, Cuba is open game. But for the United States, we've got a historical issue. And so, it's gotten even ratcheted back this year, even further with President Trump. So, we're the lone gun out there boycotting Cuba. And then the orangish, yellowish are European only. And a lot of those are associated with the Middle Eastern Spring. So you'll see Egypt and some of the other Tunisia. So the Arab Spring, Europe really took a front burner and put a lot of trade restrictions out there, and the United States was not as aggressive during that period of time. So with that, we're going to talk.
Do you mind if I
Oh,
jump
yeah.
in?
Oh, no,
Sorry.
no.
I like your map as well, and that chart. And one of the things that it also kind of triggered for me was there's an organization called Transparency International, which people are very aware of. See a lot of heads nodding, but they have an excellent website. And so when you're conducting due diligence for an acquisition, or if you are just trying to make sure that you're complying with Know Your Customer things under OFAC, that's a good place to start to get a sense of, if you know that the end customer or the end use is going to be in a certain country, take a look at the Transparency International website, and it can tell you levels of corruption in certain countries and how they measure it and so forth, and that can give you some additional insight. And that this map that you put together, Ed, really reminded me of that as well.
Yeah. So I wish I could have an overlap, because you'll see a lot of the colors on there. Transparency has, I think, deep red is the perception of the greatest corruption, and you'll see a lot where the trade controls are the most strict. Is also the deepest strict. Yeah. So the next issue would be our forecast for next year, and I briefly mentioned that Congress is supposed to act on Iran. Obviously, I don't think. So I don't know what's going to happen with that, but that's going to be that could be a very interesting political discussion that occurs. And again, I think as a practical matter, if the United States completely pulls out, it's going to maybe be similar to Cuba. The rest of the world's going to fill that vacuum, and United States business is going to be even more impacted now. I don't think that we'll ever get rid of any of the sanctions, even associated with the non-nuclear side. So it may not practically make that big of a difference, but I think that it's a psychological and a political determination that's going to show an awful lot of as to what the United States' international business is going to be like going forward, not just in Iran, but for the rest of the world.
I would say, Ed, I'd say in Iran, I'm going to just do a personal forecast and say probably for 2018, I'm going to expect that Congress will continue to certify and that the U.S. will stay in the Joint Comprehensive Plan of Action. That's just a gut. That's a gut check. I don't see us pulling out of the JCPOA during the coming year.
Good.
So, you know, that's how I think that's going to go.
You agree?
In this environment, I agree.
Yeah.
I mean, that's just, but I hedge.
Yeah, you probably still hear the president making a lot of noise about
Yeah, exactly.
Yeah, right. Just a couple of days ago, was one of the new leadership, and I cannot remember the name now, but one of the leaders who essentially just, in a very political way and very diplomatic way, essentially just kind of said, it's over my dead body. Right? I mean, it's not going to be renegotiated. Right. You know, that kind of thing.
Yeah. And the reality is I think we can't forecast absolutely what's going to happen in these areas. But I think if we look back at historical experience through different, you know, presidential administrations and so forth, and appreciating this one is exceptional in some distinctive kind of ways that we haven't encountered before. However, from an export control and a sanction standpoint, you know, the structures tend to be fairly stable over time. I mean, there was some tweaks around the edges that Obama made during his second term, you know, kind of the tweaks to relax travel into Cuba, or the beginning of the process to lift sanctions in Sudan, or, you know, of course, the most significant was the JCPOA in Iran. But a lot of the changes which were made, and with some of which are being modified back now, with respect to Venezuela, for example, they're relatively, you know, and proportionally, I think they're more like tweaks and minor adjustments. Well, remains to be seen where that will go, right. But definitely there's a lot of stability over time in these areas, I think.
Yeah, and I think so. I think that the similar thing would cover North Korea, Russia, as well. Right. Then we get kind of into the midterm elections, and I would have said, I have no idea what's going to happen, especially after Alabama. You know, you never know what's going to happen. You know, with the midterm elections, whether the staunch Republicans are going to get thrown out, or whether they're going to solidify their base, and you know, it's a crapshoot in terms of what they're going to control. And going to Craig's point about the political nature of CFIUS in particular, but just in terms of the overall political environment, in terms of how they operate and oversee, you know, international business. So what's your thought on that?
No, I agree. I mean, we experienced it. You know, you have to go back and look at the headlines throughout that whole election process. But just, you know, we were looking at it from the China perspective, and yeah, it's changed overnight. And so it's hard to predict, right? And what's the news of the day, right?
And then obviously enforcement, I foresee greater ratcheting of enforcement activity. I mean, I think unfortunately it's kind of easy picking sometimes still, and I think that people are not totally attuned to some of the easy trip ups that people in the international environment are facing in terms of OFAC restrictions and selling to Iran. And so, you know, I mean, I think it's easy, and you can send messages, and it's free money for the government. And I think that especially in the budget process, they're looking for every penny that they can get, and these enforcement agencies are obligated to try to go out and collect it. So I think you're going to see a continual ratcheting up of enforcement activities in this environment going forward. So we kind of talked a little bit about it, but now we're going to get into some specifics. You know, what sort of controls do you put in place when you receive a call from your sales guy saying that they're going to do a distributor in the UAE, Joe? You know, what sort of red flags go up to you in that sort of context?
Well, you're going to immediately start asking all kinds of questions, first of all, about the nature of the business that they want to conduct there. You know, is this distributor be able to sell into, or where are they going to be able to perform service work, things like that. There's all kinds of questions that you would start asking, your folks about this distributor operation that you want to set up there. And you want to know things about the people who are going to work there. Are U.S. nationals working there? Are the nationals of UAE? Other countries? What kind of information is going to flow there, and where is it going to come from? So just all types of questions like that is being proposed, and you're being asked to comment on it and give advice on it.
And when you go to votes going.
Don't touch the day.
Yeah, you don't want to tell your,
And Craig, we're going to touch a little bit. I mean, you're a technology company, and you have a big cloud service component to it. How do you restrict technology inside the cloud from?
Well, we have a lot of smart people who know how to do it that can track that. But that is something we're grappling with. The world is so much of what we get today is just, and it can come from anywhere. And when we set up our cloud marketplaces, which are similar to a iTunes store or Google Play Store, where you can go purchase cloud-based applications, Office 365. We're the largest, online cloud distributor, Office 365. And you need to track where it's going, right, essentially, right? And these things, people are much smarter than I am. That working Mountain Dew and nacho chips or whatever, all that is what we just keep feeding them. That they have ways of knowing where these things ping, and they track it that way. But that's one of the big things now. And point earlier too is that when we develop, some of our R&D is based in Moscow and Novosibirsk, which is in Siberia. So we've got a lot of really smart Russian developers. Look at other things too, like can they export some of the technology under the Russian regulations? So they do a lot of really high-end stuff, and some of that is protected by the other governments. So you're having it developed in India and all sorts of places. So that's another thing I think about. But it's gotten more complicated. Yeah, more to think about and track. And from a practical perspective too, is that you may have contracts with some of these vendors that say that you can only sell into certain territories under that contract, and you have to just practically, from a contractual compliance, you need to be able to track it. Right. So, and it kind of backs in. There's reasons why they limit that. So, you may not only have exposure to government, you may have contractual and vendor exposure to if you violate some of these have any obligations.
Lloyd, I know we briefly touched on that medical devices and pharmaceuticals and healthcare, that's generally kind of a healthcare-related exemption. Can you elaborate a little bit more about that and how you actually deal with that on a practical basis?
Yeah, absolutely. That's a very interesting subject matter area. I've actually been in the medical device space now a little over 2 years, prior to which I was in primarily a military industry sector, and before that in kind of a laboratory equipment, commerce control type environment. And interestingly, the companies I'd been with previously, either by policy chose not to do business in some of these sanctioned areas, or in the case of ITAR regulated goods, they were just completely off the map. There's no licenses. It's a complete, it's a complete prohibition to go. So when you step into an industry segment where you're dealing with medical devices, for example, now you do have to face the sanctions regulations. And I guess, practically speaking, one of the most important pieces of advice I could give to anyone there, and this kind of came up earlier, Craig mentioned, retain counsel with expertise in the practice of the sanctions area. It doesn't matter how experienced you are with the EAR or the ITAR, OFAC and those regulations, because they're based on a sort of a patchwork of a whole bunch of different laws and acts, and coupled with the fact that OFAC isn't that strong with writing a regulation for a practitioner and people trying to actually operate in those environments, it's really, I found it extraordinarily complex. So that's my, my advisement on that. Make sure you have some assistance from somebody who does practice there. But with respect to medical devices, a couple of things. There are exceptions and exemptions in general license. In fact, my organization uses a general license to do some limited business activity in Iran, and I found that to be quite dynamic and interesting. There's even been some changes in how that operates with respect to just 2 years ago, there was a general license just for the export of medical devices, but for example, you couldn't perform services, couldn't go to a training class, teach a doctor how to use the device, because technical assistance or technology transfer or a service was not covered within the framework originally of that license. So that was one thing, and then another thing which shifted was a difference in structure about how it's implemented with respect to, initially there was an approved list of medical devices you had to check and reference against, and if your device wasn't on that list, you weren't covered under the general license. Now it's changed into a exclusion listing, which is as long as your medical device isn't on this list, it's covered within the auspices of the general license. So I guess I would say it's an area that got some complexity. It doesn't operate like the EAR or the ITAR, and while there are structures there to help you take advantage of some of those provisions, if you're doing something with medical devices, you have to step with great care, and I think you need a really strong internal process to regulate what folks are doing. It's my experience there in a predominantly EAR 9.9 medical device space is that it's black and white. People have a binary reality. Either you tell me I can do business in that country and everything's okay, or you tell me I can't do business there and nothing's okay. And so we're in danger in Iran because not everything's okay there. But and so you have to have a lot of structures, a lot of training, and we're tightly restricting and controlling it, for example, through our European Shared Services Center. So we're not doing any direct U.S. to Iran transactions. We're not permitting U.S. person involvement at this time, although certain aspects might be acceptable under the license. So it's very tight, very structured, and highly controlled at this moment.
Well, you touched on another point that I wanted to talk about, and that is completely foreign transactions. So, your distributors and your subsidiaries in Europe are not necessarily the same restrictions as they are in the United States. So, how do you control sales completely, European-centric sales, or do you control the completely European sales?
I mean, systems. That happens all the time. A lot of the products we handle are not manufactured in China. A lot of technology, and it goes, directly to Europe and lots of places from there. But you got to have systems. That's the investment system.
It's also making sure that if you have a subsidiary in another country that can sell into countries, or they're not subject to some same restrictions that say U.S. parent, as in you've got to make sure that sometimes the U.S. nationals are not involved in that sales process at all. And then there's some complexity that happens because even though you can't have U.S. nationals from the parent company involved in that, somehow there's got to be some impact of and things like that too, right? Without getting involved in that process. That gets pretty. All three of the companies are representing mobile companies in place, and all of this complicates very. And if you have people from one of your subsidiaries, say subsidiary in China, through and visit the U.S. Parent headquarters, or you have another scenario where you have engineers who are working on the same project make sure it's fine with export regs like that. We got whole teams of projects. It has to do.
More stents, more engines, and transmissions, and more technology. That's the answer to everything. So I got a note that our time is up. I don't know whether we have time, if any, for questions on the web or in person, but if not, we will see everybody next month in January. So thank you again.